Welcome, and thank you for listening to our third webinar in our series regarding the amendments introduced by the FIC Amendment Act. During this session, we shall have a look at the record-keeping requirements in terms of the FIC Amendment Act. In terms of Section 22 of the FIC Act, an accountable institution has a duty to keep records obtained during the customary due diligence process and the records of all transactions, whether this transaction was a single transaction or a transaction that forms part of the business relationship. Customary due diligence records may include the identity of the client or persons acting on behalf of the client, authorization to act on behalf of another party, all client verification records, the nature of the business relationship or transaction, the source of funds, information on a business relationship, and the client's transactional profile. Transaction records include the following: the amount involved, the currency, the date of the transaction, the nature of the transaction, and the parties to that transaction, any business correspondence, and all accounts that are involved in transactions concluded by that accountable institution in the course of that business relationship, or that single transaction. According to Section 23, records must be kept for the following periods: records relating to the establishment of a business relationship for at least 5 years from the date on which the business relationship is terminated. Records relating to a transaction which is concluded for at least 5 years from the date on which the transaction was concluded. Records of a transaction or activity which can give rise to suspicious activity or transaction report for at least 5 years from the date on which the report was submitted to the Centre. The FIC Act does not prescribe the manner in which records must be kept. It can thus be kept in different formats, for example, by storing the original documents, photocopies of the original documents, scanned versions, or in electronic format. It is however important that the following principles are met when records are stored. Records must be easily accessible, must be available on request from the Centre or a supervising body, must be able to be reproduced in a legible format. Records must not be able to be tampered with or permit any unauthorized access. In terms of Section 24 of the FIC Act, a third party may keep records on behalf of an accountable institution, as long as the accountable institution adheres to the principles in the aforementioned slide. Where the third party fails to properly maintain the records as per the requirements in the Act on behalf of the accountable institution, the accountable institution remains liable for that failure. If the accountable institution appoints a third party to store the required documents in terms of the Act, the institution is required to provide the Centre or the supervisory body with the following information of the third party: full name of the third party if it's a natural person, registered name if it's a company or close corporation, trading name of the third party if applicable, name and contact details of the individual who exercises control over the access to the records, the address where the records are kept, the address from where the third party exercises control over the records, full name and contact details of the person who acts as liaison between the institution and the third party. Accountable institutions are required to describe in its risk management and compliance program how it will comply with the requirements of the Act in relation to record keeping. An accountable institution may establish a record keeping and maintenance of records procedure, which can consist of the following: the institution's process on how to capture and document all information received from clients, the manner in which the records will be stored, for instance in hard copies or scanned copies. This process should guide employees how to organize documentation stored. The institution's process on record retention, how the information documentation will be retained once a single transaction was concluded or the business relationship was terminated. If record retention is outsourced to a third party, Please ensure that the process is established to select a suitable service provider and to maintain the relationship to ensure that the service provider delivers proper service. Furthermore, to the process to notify FIC of the details of the third party. There must be a process to request records from storage and a process to ensure that once the time period for record retention has lapsed, the documentation may only be disposed of after taking the following into account: that the money laundering officer has confirmed that legislative requirements have been met, that there are no pending cases, that it is documented in the document record register with the reason for disposal.